2013, the Supreme Court in Shelby County case gutted the Voting Rights Act, opening the floodgates to a wave of restrictive voting laws that have seen states across the country pass. In 2022, the court overruled Roe v. Wade and the right to choose that had been the law of the land for 50 years. 50 years. The following year, the same court eviscerated affirmative action, which had been upheld and reaffirmed for nearly 50 years as well. And now, there's an extreme movement and agenda called Project 2025. Well, by the way, they're serious, man. They're planning another onslaught attacking civil rights in America.
Here are the stakes. Donald Trump is telling his supporters that they, quote, won't have to vote anymore if they put him back in the White House this year. The Supreme Court ended its term by handing Trump a shocking and unprecedented immunity for his actions if he succeeds in returning to that office. All three of the justices that Trump nominated, Brett Kavanaugh, Neil Gorsuch, and Amy Coney Barrett, joined the Chief Justice John Roberts in that decision. The Supreme Court's other two conservatives, Clarence Thomas and Samuel Alito, did not recuse themselves from that 6-3 ruling, despite both of them being mired in ethics scandals and apparent conflicts of interests directly relevant to the federal charges that Donald Trump is facing for attempting to overturn the 2020 election. Especially Clarence Thomas's wife, who attended the rally on January 6th, where Trump urged his supporters to go to the Capitol. Today, President Biden explained why, after half a century in public office, this Supreme Court has led him to call for reform.
I have great respect for our institutions and the separation of powers laid out in our Constitution. But what's happening now is not consistent with that doctrine of separation of powers. Extremism is undermining the public confidence in the court's decisions.
All right, President Biden unveiled a three-part plan for fixing the Supreme Court. It involves proposing the No One is Above the Law Act, which is a constitutional amendment rebuking Trump's immunity ruling. It would impose 18-year term limits for all justices, a change that he said would put the United States in line with most other major democracies, and it would enforce a binding code of conduct that would force justices to recuse themselves from cases where they have a political or financial conflict of interest. Joining us now is the Democratic Senator Sheldon Whitehouse, who's running for re-election in Rhode Island. He's a member of the Senate Judiciary Committee, the author of The Scheme, How the Right Wing Used Dark Money to Capture the Supreme Court. Senator Whitehouse, it's good to see you. Thank you for joining us this evening. Tell me what you think about this. There are 3 points. There's one missing, and that is the concept of expanding the Supreme Court. One of the things that the president is proposing is a constitutional amendment. We haven't done that in a long time in America, but it is movement. What's your thought?
Yeah, that'll obviously take some time because the constitutional amendment process is a very slow and complicated one. The other two are things that are bills that I have and have worked on. The ethics bill has passed through the Senate Judiciary Committee and is awaiting a floor vote on the Senate. And both in the House of Representatives and in the Senate, we have related similar term limits bills. And one feature of those term limits bills that is important is that they're retroactive. So justices that have served 18 years then move on at the end of their terms. It doesn't start in 2024, it starts when they came on. So it begins the process of turnover and refreshment at the court right away.
Does that address the concern that a lot of people have that this court is sort of in some ways so rotten that expansion of the court would be the only way to solve it? Does the retroactive term limits, which, by the way, puts us in line with other major democracies, there are a lot of things about our court that are unusual, that are not replicated in other democracies. Does that, have you done the math on that? Does that solve an immediate problem?
It ends up with a number of justices who are what people who look at federal courts would understand as on senior status. We have a judge on senior status in Rhode Island. We have a judge on senior status on the First Circuit Court of Appeals. It's a fairly standard thing. So after 18 years of service, you then move on to senior status. And on senior status, you only rule on original jurisdiction cases. under the Constitution, which are fairly rare. The regular appellate workload of the court would be done by the new justices who were appointed to the vacancies created when Thomas, Alito, and others moved on to senior status. So that would begin after the next election, in the next presidency, and move regularly forward into a regular rotation so that Supreme Court justices could no longer pick the party of their successor by choosing to retire strategically like Justice Kennedy did. It takes the politics out of the court, actually.
Let's talk about the idea. You do this idea of a constitutional amendment. It's met with a great deal of sentimental support. How practical is it? Have you thought about how that would actually unfold?
Well, they have to be adopted by a supermajority of the states, in addition to passing through the Congress. I suspect that this could go fairly quickly. You have to understand what a truly bizarre aberration the Trump versus United States decision was. It is very peculiar. It creates an immunity that is not found in the Constitution anywhere, except the Constitution has one immunity. It's for legislators, to protect them from being harassed and attacked by the executive branch so they can go about doing their duty. So the founding fathers thought about this, and they put in immunity for certain types of legislative officials, for certain types of legislative conduct, but not things like treason. And then along comes the Supreme Court and says, no, the founding fathers got it wrong. We know better than they do. They never mentioned immunity for the president, but we're going to make that up and we're going to give that to him. And by the way, we'll include treason. It just makes no sense. So I think it's a pretty rotten decision, and things that are rotten tend to stink, and stinks tend to stick. And I think that moves the public. So I think this is a doable constitutional amendment, but you have to respect the fact that this process is a slow one. It's not going to happen right away. And it certainly wouldn't happen for a Trump presidency, because he would want to protect his own criminality. And he would tell all of his own sycophantic cult followers that they had to stop any kind of constitutional amendment that might subject him to consequences for his crimes.
Senator, good to talk to you. Thank you. There's a lot more to talk about on this, and we'll continue the conversation, but we appreciate your time tonight. Senator Sheldon Whitehouse.
Thank you.